What's up, everybody? Welcome to another episode of Swan Signal Live. I'm your host, Sam Callahan, Senior Analyst at Swan Bitcoin. We got a really important show lined up for you guys today. But before that, I want to bring up some of our promotions that we have, which is Pacific Bitcoin. That's the festival that we put on every year in beautiful Santa Monica. That is October 18th and 19th. If you use the promo code SIGNAL, you'll get 10% off your tickets. And if you use Bitcoin, you'll get an additional 21% off. So we got a great speakers. Go to pacificbitcoin.com to check out some of the lists we already booked, as well as other workshops and parties. And it's just a great way to meet Bitcoiners in real life. It's always fun. So check it out at pacificbitcoin.com. Lastly, Swan just introduced no fees for the first $10,000 you spend at Swan buying Bitcoin. So if you want a really cheap way to do it, there's nowhere cheaper than Swan right now. No fees for the first 10,000. And so go check it out. There's a QR code right here. Check it out, swan.com. There's also resources and educational resources. And yeah, that's our new promo that we're doing. So very exciting stuff. So today we're going to be talking about all the regulatory developments that have been occurring really since 2022 or 2023. We've seen a lot of regulatory actions, enforcement actions from regulators against the broader cryptocurrency industry. I mean, from Coinbase to Kraken to Binance. And now recently we had enforcement actions against Tornado Cash as well as Samourai Wallet, so-called crypto mixers. And I can't think of a better guest to bring on than Zack Shapiro. Zack Shapiro is a managing partner at the law firm Reigns, as well as a legal fellow at the Bitcoin Policy Institute. He has extensive experience in this arena. And so, Zack, welcome to the show.
Thanks so much for having me.
Yeah, so I kind of mentioned that there's been a lot of enforcement actions of the past, let's say, 18 months or so. But I wanted to start with the FinCen proposal back in October of 2023, which tried to basically define what a crypto mixer is. And it basically, the Biden administration had really gone after crypto mixers as a way, to fight against illicit activity and money laundering and that kind of stuff. And there was a huge reaction from the community about this because of the broad and definition of a crypto mixer. It really included a lot of things. And I know you have some thoughts on it. So let's start there and maybe educate people about what that was and what are some of the issues there.
Yeah, for sure. So this was a proposal by FinCen to regulate what they called crypto mixers as a broad category that more or less defined any tool that is designed to obscure where a cryptocurrency is going from and going to in terms of wallets as a crypto mixer. I think two important pieces of background there. One is to acknowledge that there absolutely is illicit activity that happens using Bitcoin and cryptocurrency. There are many famous examples, but probably none bigger than North Korea using a hack of a crypto game, Axie Infinity, and then Tornado Cash, which is a privacy-preserving protocol on the Ethereum blockchain, to launder hundreds of millions of dollars that was then allegedly used for their missile program. So this is a serious problem. It is not surprising that the government would care about it. And so some sort of proposal from FinCen, I think, makes sense. Another thing that's important background here is the term mixer, when it's used by people who work in Bitcoin and crypto, usually refers to a specific type of custodial tool, usually available on the dark web, where you send your Bitcoin or other asset to someone who custodies it, and then they send you, new sort of clean funds. And that is meant to obscure where the funds are going from and coming to, but it's really a service that is run by a business. These custodial mixers are mostly used by criminals. They're mostly on the dark web. And that is a tool that the government has long been concerned with. And the truth is, if you were to go on the dark web now, probably a good number of these mixers are FBI honeypots, right? This is something that the government has been on for a while. What was really concerning about the FinCen proposal we saw in January is it broadens what mixer means, not just to include what we would normally call mixers, but other non-custodial tools like CoinJoins, which operate very differently. The sort of user base of these tools is very different. It's not primarily criminals. It's primarily ordinary people who want privacy. It's journalists, it's freedom activists, and then maybe a small minority is criminal activity. But what's really important about CoinJoins as different from mixers, and what we've focused in our reply to FinCen from BPI about, is that CoinJoins are peer-to-peer tools, right? Unlike a mixer, which is a service that is run by a company meant to provide privacy. A CoinJoin is a tool that is just available for users to use. It provides privacy for them, but it is operated by its users, not operated by a company, even if there is a company that's providing some ancillary services around it, as was the case in the Tornado Cash and Samourai that I'm sure we'll get into. And so the response that we came back with is it is really important for the government to take a look at the difference between mixers and CoinJoins and tools that are like CoinJoins, right? On other networks, there are smart contracts that have the same function, and to have different policy regarding each of these different types of tools.
Yeah, I wish they read your response, because it seems like they didn't because of the Samourai actions and stuff. But just to like reiterate what you're saying, I mean, the definition here. Let me just read some of it of what a mixer is from these FinCen rules. You say the pooling or aggregation of funds from multiple persons' wallets, addresses, or accounts, and you could just understand how that can include a lot of different things. Like what would fall into that? Would a multi-sig fall into that? Would a lightning channel fall into that? Is people pooling and aggregating funds together? There's the use of programmatic or algorithmic code to coordinate, manage, or manipulate the structure of a transaction. Again, that's like, does CoinJoins fall into that? The splitting of funds for transmittal or transmitting the funds through a series of independent transactions. I mean, you could almost argue that that's how Bitcoin works itself with the UTXO set. And so it's just the broad, it kind of left a lot of question marks for the industry, because as I recall, like what Coin Center was saying is there was a lot of guidance from FinCen specifically around non-custodial actors, right? And the ability of not holding it for a long time. Businesses built their entire businesses around this idea that they provided this guidance, but now it seems like they're completely pivoting from it. So can you kind of speak on that shift that we're now seeing with the Tornado Cash and the Samourai indictments?
Yeah, absolutely. So let me start by pointing out, when you read that language from the FinCen proposal, there are all these verbs, right? Pooling, splitting, etc. The question is, who is doing those things, right? Who is performing these verbs? And is it some party that can reasonably be regulated the way that a bank would, or is it the users that are doing that, right? And we don't normally regulate peer-to-peer financial transactions. It's probably not constitutional to do so. And so that's the question that's immediately begged by that FinCen proposal. Now, FinCen's previous guidance, there are two pieces of FinCen guidance, one from 2013 and one from 2019, and they had explicitly carved out non-custodial tools from regulation as money service businesses or money transmitters. The 2013 guidance, which is sort of the bedrock for this analysis, talks about non-custodial wallets, which are real wallets as opposed to custodial wallets where a company holds your Bitcoin and moves it for you, and says that non-custodial wallets are not they're just software, right? They are not banks, they're not money transmitters, they're not ATMs, they're just code, and they're used by people to move their money, and so they should not be regulated as money service businesses. Since 2013, all sorts of tools developed in the Bitcoin and crypto ecosystem: smart contracts on Ethereum, multi-sig wallets in Bitcoin, Lightning services. And so it was necessary to update that guidance. And in 2019, FinCen put out another guidance that provided sort of the linchpin rule that crypto lawyers have been using to advise clients on when you tip over, if you're building a tool from being not a money service business, you're a non-custodial software provider, to all of a sudden now you're a money transmitter. And the crux of it is, do you have total independent control over funds? And so if you're looking at a multi-sig setup, and there are all sorts of multi-sig setups in the crypto space that can be complicated by the expressivity of smart contracts. In Bitcoin, I think we're going to see this complicated by things like miniscript and time locks that can create different permissions for different keys. The question is, regardless of how the system is designed, does someone have control over your funds? And if they have total independent control, then they are in custody of your funds and they're a money service business, and they need to have a KYC AML regime. If they're not, then they don't. You still have to worry about OFAC sanctions, but that's a much lower bar. The entire industry was sort of reliant on these statements from FinCen. The first thing that got us worried is, as you pointed out, that January guidance, and then the DOJ, which importantly is a different part of the US government than FinCen. FinCen is under the Treasury Department. The Department of Justice is its own administrative agency. They seem to have just completely ignored all of this FinCen guidance in bringing these criminal cases against Tornado Cash and Samourai. And we can talk about sort of their new theory, but it's incredibly broad and completely inconsistent with what FinCen had said before.
In your experience, is that normal for the DOJ to ever? Because I know in the case, they basically said specifically, well, the FinCen has no authority. Basically, those proposed rules that we don't have the authority to we don't have to enforce them. Basically, is how I read it. Is that have you seen that before, where DOJ just does its own thing completely and ignores any kind of FinCen guidance?
Yeah, I mean, there's certainly examples out there of different agencies taking different views on regulations. I think this is a really stark break in a way that is unusual. What I'm hearing from folks behind the scenes is FinCen is not thrilled with the approach the DOJ has taken. I think that's important to understand for people that are looking at this as a sort of coordinated attack by the US government. I don't think that's what this is. What I think is actually going on here is DOJ has a mandate to go after money laundering using cryptocurrency, and they have decided to take as broad a view as possible that makes it easy for them to bring cases. Unfortunately, they're trampling on people's rights in the process. The argument that the FinCen guidance is not binding on the DOJ, even if it is in some sense technically true, I think is incredibly misleading and wrong. For one thing, it would violate due process for the US government, one part of the US government, to have clear guidance that people are relying on, and then to have that rug pulled by way of criminal sanctions and throwing people in prison. Another thing is the specific crime that we're talking about here is failure to get a license as a money transmitter, right, under money service business law. And the body from which you would have to get a license is FinCen. So to say that FinCen's interpretation of who needs to get a license is irrelevant, and we, the DOJ, disagree with that, and therefore we can throw you in prison, seems, highly problematic to say the least. But the biggest problem with what the DOJ is doing is that just conceptually and legally, it doesn't make any sense. The clearest articulation of the DOJ's new view of who is a money service business comes from their reply brief in the Tornado Cash case, which has done the rounds on Bitcoin Twitter. Probably many of the listeners have seen that. And it uses these sort of absurd analogies to a USB cable transmitting data, to a frying pan transmitting heat. And it says, if you're involved in facilitating the transmission of funds, and transmission is incredibly broad, then you're a money service business, regardless of whether or not you have control over those funds, which is what we had understood from the FinCen guidance. The obvious conceptual problem with that is that there was no controversy about whether funds were transferred or transmitted here, right? In both the case of Samourai and Tornado Cash, absolutely, there was Bitcoin and Ethereum transferred or transmitted, respectively. 100% that's the case. The actual relevant legal question is who is doing the transfer or the transmitting. Is it Samourai? Is it Tornado Cash? Or is it the people who are using their non-custodial tools? And if it's the latter, then they just can't be a money transmitter. They are not the party who's doing the transmission, and an understanding of the law of Section 1960, which is the penal part of the statute, the part where you can be thrown in jail, wouldn't apply to them because they were not transmitting or transferring funds on behalf of anyone. They weren't transmitting or transferring funds at all. They just built software that allowed other people to transmit or transfer their own funds using their own keys. If you were to, take the government's theory from the Tornado Cash case at its face, the insane thing is there's no limiting principle, right? Who facilitates in the context of crypto? Who facilitates others moving money? Well, everybody. If you use a ledger wallet, a hardware wallet, and you're not running your own node, and you want to move funds in a non-custodial way from one wallet you own to another wallet you own, or pay someone in Bitcoin, and you use Ledger's default node, well, they're broadcasting your transaction that you've signed with your keys to the Bitcoin network. They are facilitating the payment through their Ledger Live software. Miners, right, that append transactions to the blockchain, that find blocks, and they include transactions from people who pay them fees, are accepting money to facilitate the movement of Bitcoin from one person to another when they mine. Certainly Lightning service providers, right, even in a non-custodial system, would be money transmitters here. So everyone involved in crypto and Bitcoin would be a money transmitter under this, government theory. And not just that, you can take it to an absurd place. If we're really talking about anyone facilitating the movement of money, if I hand you a stack of cash in a paper envelope, did the company that made the envelope facilitate my payment? Because they are causing, in some sense, physically the cash to move from my hand to yours because it's all being held by the envelope. There must be some limiting principle here. And so you have to identify the limiting principle. Where is the line between you did something that somehow causally, ended in someone else moving money and you are the money transmitter? I would submit the only rational way to draw that line, the only way that you can draw the line that makes sense, is about control. Are you in custody of people's money in a way that you can move it or not? If you're not, I don't know where you can possibly draw the line.
Yeah, it just, you can just keep going and going and going if they're going to say it's a non-custodial is somehow a money transmitter. And you could see, like, I mean, do you believe the notion that, this is all about stopping money laundering and illicit activity, or do you think there is some kind of bigger narrative about stopping this industry? Because to me, I just think about getting a money transmitter license, even if this came through. It's so expensive. You have to go state by state. It's expensive. It's time consuming. Even if it made sense, it would be almost impossible for any kind of business to do this in any kind of, timely manner, especially these like VC funded organizations who, they're burning through cash and they have to suddenly get all these money transmitter license and they're just like developers. It wouldn't even make sense. So it seems like, could this be like a greater crackdown on just the crypto ecosystem itself, trying to like hinder it? Do you believe that at all?
Just to underline your point, I mean, my day job is I work with Bitcoin and crypto startups, and mercifully for the Bitcoin startups, they don't have to deal with sort of the biggest crypto regulatory issue, which is our token securities, but they do constantly have to deal with this money service business, money transmitter question, and the process of getting, it's a nightmare to get money transmitter licenses. Registering with FinCen is pretty easy. Getting state by state licenses at a minimum is going to take you 6 months to a year, generally costs $1 to $2 million. There are some services where maybe you can get it done for 500K, but that's not going to work for a pre-seed startup. And for lots of tools, even if you had the money, it's just not possible or practical to then be compliant, right? If you run, if you're CoinKite and you create Cold Card, which is now facilitating the movement of Bitcoin by allowing you to, more efficiently put a signed transaction on a micro SD and then you put in your computer to broadcast it. Cold Card can't KYC everyone who used that tool. Even if they KYC'd all of their users, then someone else could just give the hardware wallet to someone else. And so it is both, for the business models that need to get these licenses, it's burdensome and doesn't work for startups. And then there are a lot of business models that just straight up are not possible if you have to be a money transmitter or money service business. So the stakes here are incredibly high, and this is incredibly important. Is there a sort of broader nefarious crackdown on Bitcoin and crypto? I don't think that's what's happening now. I mean, look, my background is I used to work in the Southern District of New York as a law clerk where these cases are. I also worked on the Second Circuit where these cases are likely to be appealed. I grew up in DC. I know a lot of folks who used to work and do work in government. And my sense is, first of all, there are absolutely some people in the US government who just straight up hate Bitcoin and crypto and are trying to kill it, right? Brad Sherman, Elizabeth Warren, you know who these people are, right? And Gary Gensler to some extent. I don't think that's what's happening with FinCen or the DOJ right now. I think that this is more or less collateral damage. I think they don't understand and perhaps don't care about how important this technology is for financial freedom and just freedom in general. Part of the mission at BPI is to help educate lawmakers and policymakers on this topic. I think if you're in DC for a long time, if you're especially, Democrats in particular, have a view of the world where you trust the government and you trust institutions, and the feature of Bitcoin and crypto that it's something that's necessarily meant for the government not to be able to interfere in is sort of anathema to the way they see the world. And so when there are these clashes between, hey, we need to go after people that are committing money laundering, and genuine concerns about financial freedom, they're less concerned about the financial freedom half of the equation and more concerned about going and getting the people that are committing money laundering. I think that is different than an all-out assault to take down Bitcoin in the way that, like, I think if you're on the crypto side, like the SEC right now basically thinks that anyone issuing a token is breaking the law, and they're trying to more or less shut down like crypto in the United States. I don't think that's what's happening here with the DOJ cases and the FinCen guidance.
Well, it did remind me of Elizabeth Warren's Anti-Digital Money Laundering Act. Just some of the language in there about unhosted wallets, for example, and how that would apply as like a money transmitter and how silly that was. And there was some reactions from it was like a chilling effect from some of these enforcement actions as well on the industry. Is this an attack on self-custody itself? And you saw Phoenix Wallet, for instance, get taken or voluntarily take themselves off the app stores in the United States. And some people said that was an overreaction on their part, but they felt compelled to do that in reaction to these enforcement actions. So do you think this carries over to self-custody? Do you think there's any kind of these cases could set precedent that would impact the ability for people to take self-custody in the United States?
Yeah, first, I think we need to separate out DAML, the Elizabeth Warren draft bill, and these cases. DAML 100% is an attack on self-custody, right? It is Elizabeth Warren trying to ban the sovereign use of Bitcoin in the United States, full stop. She knows what she's doing. That's what it is. I don't think that's what these cases are, although I 100%, they do have a chilling effect, right? I mean, you can see what happened with Wasabi and Phoenix. My view is, I think Phoenix in particular overreacted. I wish Wasabi would stay and fight as well, although I understand in their case why they did what they did, right? These cases are more on point for their business model. Really like the Wasabi team. I think it's unfortunate what's happening there. And, I got a dozen calls the week after this case dropped by, Bitcoin clients that are asking, like, is my product now illegal? And I had that conversation a whole bunch of times. Look, my current view is that if you're truly a non-custodial product, and look, this is not individual legal advice to anyone that I don't represent, but more or less, I think the FinCen guidance still stands. Absolutely, these DOJ cases run contrary to it. I think their legal theories are overbroad and ridiculous. I'm optimistic we'll be able to beat these back in court, and there will be initiatives that I'm sure will be announced soon to try and fight that battle as strongly as possible. It might be down the road that there will be more enforcement actions that are more of a direct threat to self-custody, both building self-custody tools and individual self-custody wallet usage. I don't think that's what this is yet. I think this is the DOJ specifically going after companies that they see as facilitating money laundering, and then trying to use whatever tool, even these overbroad interpretations, at their disposal to try and win those cases. I would also note, and this is something I say to clients a lot, there's a difference between even for people that are on the line between, is this custodial, is this non-custodial? There's a difference between a technical money service business violation and the type of case where the government will actually prosecute. It's not necessarily, the line where you'd want to take your freedom in your hands. But if you actually look at the cases the government brings, in almost all of them, from the very beginning of cryptocurrency with Charlie Shrem to the cases a couple of years ago involving Bitslato and CZ from Binance to these recent actions, in all of these cases, there appears to be evidence that the defendant knew specifically that their tool was being used to launder criminal funds. And that is sort of the deciding factor as to which cases the government actually going to criminally prosecute, as opposed to, there's discussion and the tool shuts down, but no one ends up in jail. And so, right now, I wouldn't say this is an all-out attack on self-custody, although, that's not to say that the precedent that's set in these cases can't be used in the future very easily for an all-out assault, which is why these cases are so important.
Got it. Yeah. So Alexei Pertsev, he's one of the founders of Tornado Cash. He was recently found guilty of money laundering in a Dutch court, sentenced to 5 years. And I was surprised when I read that, the more details of that case, because it really was about the intention there and about basically just the concealment. And I was kind of shocked by the verbiage, because it's basically like, well, you guys created this and you guys completely knew that you would provide privacy, and so you're guilty of the money laundering. And I know Dutch courts are different, but I wanted to kind of get your reaction first off on that guilty verdict, and then talk about how, if there would be something similar with the Roman Storm case with the Southern District of New York, what's going to be the differences there? Because in my opinion, it was just crazy, some of the reasoning behind the Dutch courts guilty verdict in that case. So I'd love to get your reaction from that.
Yeah, another piece of language I want to highlight from that case is they said if they wanted to stop money laundering, they would have built in ways for them to freeze funds that they thought were money laundering, right? And so creating this neutral piece of software is the sort of thing that made them guilty of this intentional crime. Look, I think that is scary, authoritarian sounding language. I don't particularly worry about that for the US cases. I think the real difference here is in the United States, we have the First Amendment that I think would clearly protect at least the act of writing software. The sort of quote unquote bad facts here, the government's going to try and use. And look, even people that I've seen hold themselves out as Bitcoin or crypto lawyers on podcasts sometimes talk about the fact that Samourai had a centralized coordinator for the CoinJoin, where they help people determine the timing for the transactions that they did to obscure where their funds were and provide privacy. And then there was this relay system with Tornado Cash that's analogous, and both companies made money from these services. Those are different than someone who just purely writes a piece of code. And I think the argument in these cases in the US is going to be about, do the sort of ancillary activities around the protocol constitute the type of ongoing services that can be regulated as a money service business? For the reasons I said before, I think it's very important that the answer is just straight up no. The actual money transmission was happening by the users and not by them. And so it doesn't matter what services they provide around that or what scaffolding. The question is who's moving the money. But in the Dutch case, it is really more squarely about writing the software and the intent behind the software and the lack of controls. That wouldn't, at least I really do not think that would fly in the United States, because writing code would be protected as free speech. It's unfortunate that the sort of early cases where we have to test these principles in the US have imperfect facts, right? There was, it appears, actual money laundering that went through both of these systems. It wasn't a pure case of writing code. I would love to, in the future, look for cases that we can bring against the US government, if there's policy overreach where it is a pure example of someone writing code and stepping away. I think that would be really helpful for setting a clear precedent that, code is protected by the First Amendment, full stop, if all you're doing is writing code. But I think the Dutch case is dissimilar enough that it won't be a huge factor in the US cases. And I wouldn't expect a similar result here.
Yeah, that was it was just crazy. I don't know much about the Dutch court system, but it really was about writing code. They really got him for that. But in the opposition from the DOJ in Roman Storm's trial in the United States, they specifically said that that's not what they're going after. And I thought, before we can go into that a little bit, they actually talked about the code is speech in that. And they said that it was kind of nonsensical, because I think that was one of Roman Storm's arguments for why they should throw out the case, basically, was that, oh, well, code is speech. And Bitcoiners always talk about like Bernstein versus the DOJ in the 90s and like how code is free speech and protected by the First Amendment. But the DOJ was basically like, that's nonsense. And they said that there's a lot of precedent where, computer code, doesn't violate the, free speech or whatever. And I wanted to get your reaction about that, because that's something that's I've echoed before about Bernstein and how code is protected by free speech. Like, how true is that?
Yeah, broadly speaking, publishing code is speech. Now, there's a whole very complicated, convoluted, centuries now of case law about interpretation of the First Amendment and the difference between speech and speech acts, right? Like the famous example, yelling fire in a crowded theater is not protected First Amendment speech. There are other, incitement, obscenity. There are some exceptions to free speech. And so if you were, to write code specifically for a criminal purpose and use that in a criminal way, that's not protected, even though in some sense you're doing it via speech. But what you're being punished for in those cases is the action that you're taking via your speech. It is speech in context. And in a case where someone is just writing neutral code, right, that allows people, for example, to have peer-to-peer internet cash, or, a code that allows people to set up federated mints, or a code that allows people to engage more easily in collaborative custody among their community, or get privacy on the blockchain, and you just publish that neutral code. My understanding of First Amendment case law, that seems pretty clearly to be speech.
Got it. Yeah, because they're not going after that in the DOJ. They kind of threw that out when Roman Storm tried to, make that argument. But they're like, we're not actually going after writing code for you right now. We're actually getting after you because of basically you ran the front end. That's basically what they're saying. Basically, you ran the front end for all this. You paid for the, the server costs. And then you also like tried to collect for profit, right? You ran, you basically had these tokens. There was relayers. You made money on the fees. And so you were incentivized to keep this going. And that's where they're going to get in them. You talked about the scaffolding. And so what are your thoughts about that? Because I think this is where you and I kind of started to bicker a little bit on Twitter. It's like, it's this idea of decentralization and whether Tornado Cash was actually as decentralized as they led themselves to believe. And if there was anything they could do once they knew that illicit activity was going through there after, say, the Ronin bridge hack, where we know that, like, could they have done anything to either hinder them at all? And whether they did that or not once they knew that it was happening. And so let's talk about that, because that's their reasoning. Basically, they're like, we don't even care if you have control over it. We don't care that you wrote the code. We care that you ran the front end. There was some kind of profit incentive for you to keep the system going, and you did nothing to hinder it once you knew that there was illicit activity going through there.
So I want to talk about the scaffolding, and then I think decentralization is a slightly different but very important topic related to this. So in terms of scaffolding, I think you need to look at the different crimes with which, in both Tornado Cash and Samourai, the defendants were charged with. Everything I've said so far about control is conceptually and legally necessary is about the money service business charge. And that is the precedent far and away I'm most concerned about, and the one that's really important for do any Bitcoin tools work. The money laundering charges are a slightly different story. When you charge someone with money laundering or conspiracy to commit money laundering, the actions that they take in and around the protocol can matter in a way that I do not think they should matter for the MSB MTL question. The problem for the government there is that for money laundering, it's a specific intent crime. You really did have to intend to either hide the proceeds of criminal activity if you're charged with money laundering yourself, or work with others to help that happen if you're charged with conspiracy to commit money laundering. And I honestly have less of I think it's a little bit more complicated in Tornado Cash around when, you can be guilty of that. But the question is really, did these guys knowingly help others launder, illegal proceeds, or was this just a neutral privacy tool? And I think this is a little bit less important than the MSB question, but I do not think that providing infrastructure for a neutral privacy tool means that you have the intent specifically to help criminals launder money. In the Tornado Cash case, in the Samourai case, I think the question is going to be, is there evidence in this case that shows that these guys intentionally helped criminals launder money? And if there is evidence of that, then they're guilty of that crime. But that's a high burden for the government to meet. And one of the things that is really concerning here is that, the money laundering charge carries a really heavy sentence and is harder to prove because you need specific intent, whereas the MSB charge is less of a serious issue, but it creates much worse precedent. And so I'm worried the government will put pressure on defendants to, they'll take away the money laundering charge, which is scarier in terms of how long you'd be in prison, to get people to plead guilty to the thing that creates, precedent that stacks the government's deck against future defendants. How involved you are, I don't think profiting really matters, right? To what extent you use the ancillary services specifically to help criminals launder money. I mean, the advice I've given every client is, obviously, if someone asks you to help do something that's a crime, don't do that, right? Talk to a lawyer, maybe report it to the government. That's very different than maintaining neutral privacy software. And so that's where I think the sort of ancillary services come in and the front end comes in. We can talk about like how culpable should a front end be for what the back end does. I mean, that's a separate interesting question, especially like in the securities brokerage context, which is different than this DOJ question. And it's an issue in the Coinbase case, and it's at issue in the Uniswap and the forthcoming MetaMask.
Yeah, I'd love to, if you want to get into that.
But before we go to that, I think there's this other question about sufficient decentralization in the MSB MTL context before we move to securities law. There are two axes on which I think this MSB MTL battle will be fought. The first one is what we've been talking about this whole time so far, which is about how much control do you need to have over others' funds in order to be a money service business or a money transmitter. The Samourai and Tornado Cash cases are cases where there are clear entities you can point to that would be the businesses if there's a business involved, right? They're both business entities and specific people that provided services. And what's at what's controversial, what's at issue is, did they have control over other people's money? There will be other cases, I think specifically involving eCash, involving multi-sig wallets, involving treasuries, involving DAOs, where it will be non-controversial that if there were an entity, they would be in control of other people's money, right? If you put your money into a federated eCash mint, you don't have control of the money, the mint does. But the controversial part is there an entity that can be regulated as a money service business or subject to the Bank Secrecy Act or have to get money transmitter licenses? That's going to be a very different type of case. And I think that's incredibly important in the Bitcoin space for the viability of federated mints as a way to make non-custodial Lightning more user-friendly. It's going to be really important for collaborative custody models like Casa and Unchained are doing. And federated sidechains, right? Like Liquid, right? Is Liquid a money service business or not? And there, the decentralization of the federation is what matters. On the crypto side, it's going to be the same thing for DAOs, right? And people who control governance tokens over smart contracts, like in Tornado Cash. And so the importance of the decentralization question there is, can you say that the collective of token holders is really just a company or a group or some sort of unincorporated entity that the government can treat as a specific actor and regulate or go after as a group? I don't think in the Tornado Cash case, where the founders owned a minority of the tokens, that makes sense. And there is a parallel question, again, when we step over from the MSB MTL Treasury question over to the SEC securities law question, there's a parallel question if you're like launching a token, right? Is your protocol decentralized enough so that your token is not a security? I think that is a different and difficult and higher bar, because there you're not asking, is there an entity that can be regulated as a bank? You're asking, are there particular groups of people who you're betting on to do work to make your token price go up? And there, like, the line I think is more difficult. Personally, I think Bitcoin is clearly on the right side of that line. Right? There's no Bitcoin specific company who we're all reliant on in order for the Bitcoin price to go up if you're investing in Bitcoin. I also think personally, Ethereum's on the right side of the line. It did not used to be. In the early days of Ethereum, obviously you were reliant on Vitalik and the Ethereum Foundation to make your ETH price go up. Now, I don't think that's the case. However, like a very large majority of like crypto companies, I think, are on the wrong side of that line. When you're buying a token, you're essentially investing in a startup. But that is different, I think, than this question of, does the fact that the Tornado Cash founders were significant token holders and tried to influence the community in one way, I don't think that turns them into a type of entity like a bank that undermines their whole argument that it was the smart contract and not them that was doing the money transmission.
I actually, in the Dutch case, they actually bring up kind of what I brought up, is that they did allocate a substantial amount of tokens to themselves, and there was a history of them influencing the direction of the protocol. I bring up, they created a DAO, but then each founder received 800,000 Torn tokens, and with the investors, it was about 30%. And then they made a plan to basically vote through their plan to have a mechanism in place where they would get profits from the fees, all the token holders. And obviously they owned a lot of the tokens. And to me, it's just like, I don't know why they had to go that route of, creating a token from the first place, taking on that regulatory risk, but then giving themselves so much of the token. If they truly wanted it to be decentralized and they weren't seeking profits, you would think they would have just distributed it more to the community and not so much to themselves. And that if they already influenced the direction of the protocol because they did hold an outsized portion of the tokens, why couldn't they do that again when the illicit activity started? To at least try. Like, they might have not gotten something through, but they didn't try at all. And it's kind of like, to me, it's almost like if there was a casino in a hometown, and so you knew that the North Korean hackers stole 625 million. There's private messages that show that they knew that almost 15% of Tornado Cash's volume consisted of funds that can be traced back to that hack at one point, and they knew that. Could they have done anything? Because to me, it's like a casino in a hometown where you knew that somebody stole funds from the entire community, the funds, all your neighbors, and they came to your casino, and you just kind of let them, get chips and start gambling, start washing those chips, all those funds, and you collected profits while they did so, you did nothing to like lock the front door, even just, do nothing. Like they could have taken down the website. It would have still been working on the back end. If somebody was more technical, they could have still ran the code. It would have just made it more challenging for them to use the service, but they did nothing. So that's part of where my qualms come with it all. It's like, I do feel like there was some unlawful activity here with the token issuance, with the fact that they issued a lot to themselves, and then they knew that the illicit activity was happening, and they had prior histories of being able to influence the direction of the protocol. And I'm just trying to explain my thought process, and
Yeah,
like
for
you
sure.
can kind of poke holes through it, but that's kind of what I was getting at with my tweet like a week ago or so.
Yeah, so let's talk about a couple of parts of that. So the first important question here is, does the fact of the Tornado Cash governance tokens change the legal result? And again, what we're looking for here, is there a cognizable entity, a group of people who are conducting services, who are moving money on behalf of other people, such they should be regulated under the Bank Secrecy Act? That's question number one. My understanding of the way Tornado Cash worked is that the smart contract that was actually doing the obscuring of where funds are going from, and two, was immutable and was not changeable just by a vote of the governance tokens. Some of the ancillary stuff around it was changeable by the governance tokens. So first of all, the question is, I don't think the existence of these tokens changes the question about control here. B, to the extent that there was important stuff germane to any of these charges, I don't think it should apply to the MSB MTL charge, but to the other charges having to do with what the token holders are doing, I think it is bad precedent. I mean, it's a closer question, but it's bad precedent to say just because there are influential community members who are pushing in a direction who own a minority of the tokens. It's different if they have sort of unfettered control, right? If they had a majority and they can just push things through. But if they are minority vote and they have social influence, saying that all of a sudden that turns them into the equivalent of a bank, or it makes them take the actions that the community took, I think that is damaging precedent and seems wrong to me. But then there's the question of like, okay, why do tokens in the first place? I think if you ask them, they would say the idea behind tokens is to distribute governance, is to have some mechanism to have community control. I think that might be a legitimate answer, right? You can do things differently in Bitcoin with wallets, or you can do it with accounts. You can sign without tokenizing, but tokens can be a convenient way to distribute control. And then why did they distribute so many tokens themselves? There, I have to assume the answer is greed, right? I mean, look, this is the part that I think Bitcoin maximalism, by and large, gets right about crypto, is there are really, really, really bad and difficult incentives to overcome when you can print your own money. A lot of what I do is help startups raise funds. Some of those startups, increasingly in the Bitcoin and crypto space, have tokens involved, and those are usually pre-sold, some percentage pre-sold to investors. Some are retained by the team, and not just there's this securities law question that everyone has to face, but there's also often a conflict of interest between what are the sort of tokenomics that will make the thing that you are building work over the long term versus what do your investors insist on for you to be able to raise VC money, or two, if you go with this plan, right, this high insider allocation, you can have enough money to retire as a wealthy person for the rest of your life, regardless if you find product market fit. And I think that those incentives are very hard to overcome. I think those are about greed. I think that is the main reason why we've seen billions and billions of dollars invested in crypto and almost nothing useful come out of it so far, is because the incentives are completely warped by the way that venture money flows and the incentives around issuing your own token. I think that's all legit. I don't think that changes the answer on these criminal charges. And I think if that is the thing that these criminal charges end up turning on, that's going to come back to bite us in the context of federated tools on Bitcoin that are very important, I think, for Bitcoin adoption and scaling.
Got it. Yeah. And I just read I read it, and the fact that once they knew they were screwed, they literally said we're effed when they found out that the sanction group was using Tornado Cash, that they use a third party and Russian IP, VPNs to basically sell their Torn tokens on Russia Binance. And then we're trying to hide it from the other Torn token holders, their activities. It just like, that just seems like another pump and dump to me. And I had to like call it out because I don't agree with a lot of what the DOJ is doing. But I'm going to call out like an unlawful activity if I see it. And so it's kind of tricky. It's a tricky dilemma. But the Samourai case was even more interesting because it seemed like thinner. Like they really just looked at some tweets that they sent out. You know, you talked about some of the language, and to me, it's almost like some low hanging fruit. Because what was interesting though in the Tornado cast is what I read is they said the courts have recognized that the act of marketing a laundering service to criminal actors can be evidence enough of a defendant's intent to engage in money laundering. And so can those just tweets and some of those statements that the Samourai guys made, can that come back to haunt them, or is that kind of like pretty thin arguments?
I mean, can it come back to haunt them? I'm sure in some sense, yes. And I'm sure in some sense that is why this was an attractive case for the government to bring. I don't think that enough will be able to get a conviction.
Got it.
I think if the government is going to win on the money laundering charge, they're going to need more than at least the tweets that have been available publicly, which do not seem to clearly demonstrate an intent to facilitate money laundering. Those are not, they don't make a conspiracy. It's got to be something else the government has. I don't know what the government has. That will be very fact dependent about does the government have enough evidence to show what was in these guys' minds and show that they intended specifically to help specific people launder money. We'll see. I think that's different than the sort of bright line questions around the MSB charge. Yeah. But I think both not be enough for conviction. And if it did lead to conviction, it would be really troubling, I think, from a free speech perspective, if the statement, welcome, new Russian oligarch users is enough to, prove intent for, money laundering charges, even if it was stupid and counterproductive to say that in the first place.
Yeah.
Now, one other thing to mention, because this is both a feature of Samourai and Tornado Cash, in the Samourai case as well, these guys made money from the operation of their protocol, right? If you think about what the CoinJoin did, it's a bunch of users making Bitcoin transactions of equal sizes all at the same time to make it hard to trace the inputs to the outputs. And what the Samourai company did was they had the centralized coordinator, the software that told people when and how to make these transactions. And then as part of those instructions, some of the output that people would have when they moved this money would be a payment to Samourai, right? And so they made money from the operation of their CoinJoin. I think that's just completely not germane to the MSB or really the MTL charge here. You can think of an analog example. Let's think of an analog case where people really are guilty of money laundering that works the same way. Let's say, dark web vendors are trying to send cash in the mail to themselves through the US Postal Service, and someone runs a website saying, all right, everyone put your cash in the mail at exactly this time and exactly this day and go to all these mailboxes. And by the way, for this service, if you want to keep having access to my website that helps you do this, send me $5 in the mail. That person would absolutely be guilty of conspiracy to commit money laundering. They are reaching out to people they know are criminals, and they are intentionally helping those people launder the proceeds of funds. However, they're not a money transmitter under any circumstance, right? It's the US Postal Service that's moving the cash around, right? It's not the person who's giving the instructions. And so, and I think there's a similar analysis for the relay in Tornado Cash, but these ancillary services and the payments, I think, are just entirely not germane to the question of who is transmitting the money.
Yeah, because Samourai was basically that centralized coordinator, like you said. They were kind of just like blinded to who and what was being sent, kind of, but then just like almost like a message coordinator, kind of connecting the different users, and they were collecting a fee from that service. I think you brought up like incentives before, and I think this is important because it just seems like both Samourai and Tornado Cash, the incentives force them to be potentially not as decentralized as they maybe wanted to be because they were trying to make profit. And so, I just think about Satoshi. I think about the fact that he came here, he built it, he gave it to us, and he walked away. And it just kind of grew organically. Do we need more technologies like that? Is this going to incentivize developers to build things and just release it to the world, not try to profit from it, not try to have a corporation behind it, not try to get investors to bring money, not have a central server, anonymous, just release the technology to the world? Because I think that's what we need. Because if we had, if the Tornado Cash really wanted just to release this technology and not try to make money off it, they probably could have. They just released the code. And if it gained traction organically, great. And it seems like what they wanted to do was provide centralized services, which made their services more convenient for the users, which is probably a good thing. But then they tried to make a profit off of it. And maybe from this, like even from the after this, like Samourai wallet, we see the join markets start to gain popularity, which is a lot more decentralized option. But Samourai was so much easier to use because of the centralized coordinator that it took a lot of market share away from any of these more decentralized options. So I just kind of think that there could be like a silver lining to all this, because I think you need to build technology, and this is very cypherpunk, that can't be stopped. And it's like F.A. Hayek in the 80s. We had to figure out sly roundabouts ways to, build things that can't be stopped, that can't be, stopped by any kind of form of law, that has a, just it's like a virus. It just spreads. So what are your thoughts on that? Because I think it's just some kind of like, it's like a positive outcome that could be from these enforcement actions.
I think as a descriptive matter, if there are more and more enforcement actions, both on the securities law side and on the sort of Treasury, KYC, AML side, as a descriptive matter, that will incentivize more anonymous open source development that looks more like the invention of Bitcoin itself. I think the securities laws are getting strict enough that we're starting to see that in crypto. There's a very popular exchange. It used to be, right, people who were building decentralized finance protocols, they would have a startup, they would have some argument as to why their token wasn't a security. You wouldn't directly get fees from the protocol. And then that just seems not to be working, right? The United States government is going after Uniswap, which is one of the most popular decentralized exchanges. Out of that backdrop, I think you see newer startups like GMX, which is a derivatives exchange where they're just openly sharing the revenue from the protocol with their users, and the team is anonymous, and they did not accept the same type of VC funding, and they didn't dox themselves. I think we will see stuff like that, right? I think everything that has a centralized point that can be attacked, if the things keep going the way they're going, they will be attacked, and the things, just in a Darwinian sense, we'll be left with are the things that are truly decentralized and peer-to-peer. And in some sense, having hardened infrastructure like that, I think will be a good thing. I don't think we want to give up on the convenient stuff, right? I don't think that like the best outcome here is we're left with, pirate dexes and, only peer-to-peer sort of underground tools. I think, especially in the United States, we should, stand up for our rights and demand that we be treated fairly and that this stuff work for its users. But certainly the government is setting incentives that will make it harder for things to get funded in a centralized way and operate in a centralized way. And the more decentralized something is, the more just naturally immune it is from attack. Now, that is why, look, there's a lot of conversation in the Bitcoin space about why everything about crypto is bad. And as I explained before, I think a lot of the incentives around creating a token are in fact bad. And a lot of the bad incentives are driven by private market investors as well. I would encourage Bitcoiners to take a look at two sort of concepts from crypto, though, that I think will be important in this world where things move in a more sort of peer-to-peer centralized way. And it's really important to separate out the very early versions of these things that exist now, and certainly the tokens associated with them, from the concepts themselves. But I worry that as Bitcoiners, we sort of stick with the concept of Bitcoin is the best money. And look, that's true. I don't think there is reasonably going to be a competitor to Bitcoin. But if you look at like, why is Bitcoin successful? What did it do that's special? The white paper says it's peer-to-peer electronic cash, right? There are, peer-to-peer is super important. It's not run by a company. It's run by its users. And then cash is really important because it is a bearer instrument, and it's a new form of money that is backed up by game theory and cryptography, and not the monopoly of violence by the state and contracts around that. That worked for money. I think Bitcoin is more or less perfect in that way. Bitcoin, I think can and should have upgrades to make it more usable around the world. I'm excited about, Miniscript on level 1. I'm excited about eMints. But, Bitcoin, the asset, is more or less, I think, the perfect money. There is a question, though, are there other functions of the state that you can replace with game theory and cryptography? And there is a real, the Oracle problem. We're not going to, in a permissionless way, have real estate on the blockchain or anything like that. The whole sort of crypto sector of real world tokenized assets and the stuff BlackRock is doing, that'll only work if the government allows it. But there are some things I think we can maybe do in a truly peer-to-peer way that's backed up by game theory and cryptography, using sort of the tools of signatures and using multi-sig wallets. And one of those is the concept of a decentralized autonomous organization, right? Whether or not it uses AI to be autonomous, I think the idea of having people come together and having incentives set that allow people to spend Bitcoin, spend dollars just using code as an alternative to, the Delaware C Corp, which is currently the best way to organize people and money. I think that would be exciting if we could find some way to have people come together to work on projects in a more or less trustless way, using shared resources and using sort of multi-sigs as a way of arbitrating where the money should go. We are not close to that now. All of the so-called DAOs that exist are much, much, much worse than a Delaware C Corp in terms of how they function. And many of them have huge incentive problems around token distribution and tokenomics and insider and investor allocations. But I think that concept is something that's worth exploring, and specifically worth exploring using, we don't even really need new Bitcoin technology. I think multi-sigs and mini-script are a great way to get started down that path. And the other is decentralized finance, right? Which is very different than the DeFi protocols that exist now, very different than the DeFi tokens that exist now. But if there are, either digitally native or close to digitally native assets, if we can have some way to have, a dollarized asset, if Tether is able to survive whatever is coming down the regulatory pike, if we can have a way to swap out Bitcoin for those assets in a peer-to-peer way without a financial institution in the middle using something like a smart contract, that also seems like a worthwhile goal and something that could happen in principle, since these are sort of purely online activities.
Yeah. No, I think those are solid points, and I agree with a lot of it. I think looking at, I always thought of Ethereum as a couple of different things, but one of them is like a sandbox. I mean, you see like ZK rollups now, kind of using that technology start to get implemented at Bitcoin, start to experiment a little bit. There has been a few things that they've developed over there that are kind of good ideas, and then you're like, oh well, why don't we implement it on Bitcoin, or why don't we see what we can build with it on Bitcoin without changing the consensus protocol, obviously. But
or even on other chains, right? Like, I am pretty agnostic as to what should be built on Bitcoin. Obviously, now there's a huge renaissance in people trying to build DeFi on Bitcoin, meme coins on Bitcoin, all that stuff. I don't really want to wade into that debate. The answer is, I guess I don't really care, but my view is the fixes are worse than the disease here. And none of this is to say that like Ethereum is good money. I don't own any Ethereum. I don't think it's good money. I don't know what its monetary policy is. And so I never want to save an Ethereum. But might it be that there is some other permissionless network which is useful for applications, the way that, the token functions like a subway token? I don't know why we need to be reflexively resistant to that, right? I think we're past the point where any of these things are really competing with Bitcoin as sound money, or anyone who thinks that, like, they're just delusional at this point, right? Like, right. Bitcoin, I think, has a moat for sound money that you just can't recreate now. But the automated market makers are a really cool concept, right? The idea that you take something that previously had to be done by a financial firm and you just replace it with an algorithm, and you're able to, price assets peer-to-peer that way. Like, that's pretty cool. I don't know if that can be built on Bitcoin. If it can be built on Bitcoin, I don't know if that's good for Bitcoin, because it might clog the chain and create fees and the whole debate that's happening right now with ordinals. I don't know. But I think we need to be a little bit more open to this technology rather than, treating it like a religious taboo.
Yeah. Yeah, I think I would probably be on the camp of like an ossification guy on the base layer. I just think there's some of these second, third order effects that are hard to predict when you make any kind of changes to allow for increased functionality. I think that's one of the things you can learn from Ethereum. Any kind of added complexity leads to unknown risks down the road that you didn't think about. And so I think if any of these things happen, I kind of believe we're in like layers and somehow trying to scale it. People smarter than me, basically, that are more technical, but I did want to, like, if you have a little bit of time, are you okay with time? Do you have a hard stop?
No, I'm good.
Okay, cool. I just wanted to talk about the consensus lawsuit a little bit, because I found it pretty fascinating. So what was revealed in there. So for people who don't understand, who aren't familiar with what's going on, Consensus received a Wells notice, which is like a warning from the SEC that enforcement actions coming down the pipeline. And really, they immediately sued them. And in that lawsuit against the SEC, Consensus basically revealed that the SEC has basically classified ETH as a security all the way back in since 2023. They shared a internal formal order from somebody at the SEC that instructed the employees to investigate and subpoena anybody who was buying or selling ETH. And it was really around the ETH 2.0. And when they shifted to a proof of stake, it seems like the SEC has shifted its stance. Now, Ethereum and anybody who's built on Ethereum has used past comments from the SEC, basically from the Hinman case, which basically said that something can grow decentralized over time and that Bitcoin or Ethereum is a commodity. There's been comments from the CFTC that said Bitcoin is or Ethereum is a commodity, excuse me. And now it seems like the SEC has pivoted, and they didn't do this publicly. So even Gary Gensler was testifying in April of last year, and they said specifically, is Ethereum a security? And he just deflected the question. But now consensus is saying here in the lawsuit that there was a formal order saying, hey, investigate them and subpoena them, basically saying that they consider them a security, and that they actually subpoenaed them specifically about the merge, about Consensus's role in the merge, about how it came to be. They've really been poking and asking questions about how that all happened. I think they're thinking like, do any of these entities actually control or manage or guide the Ethereum network? And then they also reached out to the Ethereum Foundation. And there was a disclosure on the website that said, we've never been contacted by any kind of state agencies. And now they've since taken down that disclosure from the website, meaning you can kind of indicate that they have been contacted or some kind of state agency has inquired about some of these things with the Ethereum Foundation. And then it's this whole idea of like whether Ethereum is a security or not, which, I mean, we can go down this rabbit hole, but I just thought it was like a kind of a bombshell that Consensus revealed some of these things about the SEC's investigation of Ethereum 2.0, as well as the classification that they've been doing internally without saying so publicly. And so a lot there, but I just wanted to give a review. Yeah. Maybe I did a good job, maybe not, but
No. A lot of that is right. I want to just signpost two things to begin with. One is the forthcoming SEC lawsuit against Consensus, I think, is not going to be about Ethereum. It's going to be about MetaMask and whether MetaMask is essentially, that's a non-custodial tool as well. It's a wallet.
Very similar, right?
As a brokerage. It's very similar to the like Tornado Cash.
Right. Like the front end, and they're collecting something on the MetaMask swaps.
And the SEC, for people who are interested in that, the SEC, that was their only real loss in the motion to dismiss in the Coinbase case, is that the Southern District of New York found that Coinbase's wallet that more or less did the same thing as MetaMask was not acting as securities brokerage because it was non-custodial. And so I think the SEC is trying to get different precedent on that. And that's what that's. There is a interesting and different question about like ETH's status in the merge, and sort of my longer views there. I wrote an op-ed for Blockworks, sort of setting out my views for people who are interested. In brief, I do think it's important to understand like the way US securities law works here. Most securities that we deal in the United States are securities on purpose, right? The three most famous categories. One is equity securities, which is ownership in some business enterprise. If you're buying stock in a company, that's obviously a security. It's a security on purpose. Everyone knows that. Second are debt securities, bonds. Those are meant to be securities. They're fixed income obligations, uncontroversial. They're securities. And then various like on purpose contractual securities, options, warrants, swaps, stuff like that. Those are meant to be securities. When we talk about crypto, we're talking about none of those categories. We're talking about a fourth bucket, which is different than the first three, called investment contracts, which is meant to be a catch-all category where something that is usually not itself a security is sold in some way that makes that sale a securities offering. So when we're talking about, tokens and securities law, we're actually not asking, are the tokens themselves securities? They're not, they're just code. The question is, are the tokens sold in some way that implicates the securities laws and gives the SEC jurisdiction where that sale is an investment contract? It's governed by, I'll go very quickly through this and everyone's heard, called the Howey test, which asks these four questions that build on each other to determine if the offer and sale constitutes an investment contract. Did someone invest money in the thing? For almost every crypto token, the answer is yes. That's defined very broadly everywhere except the Ripple case, which I think is going to get overturned, to include paying money, paying crypto, paying fiat, providing services. Even accepting an airdrop has been found to be enough effort to be an investment of money. So everyone loses on that one. Two, is your investment in a common enterprise? Common enterprise generally means either horizontal commonality. So if I invest in something and you invest in something, do we win or lose together? For any fungible token, like that will be true because there's a market price. Even for NFTs, there's usually a floor price. And so almost everyone loses on that. Similarly, vertical commonality is, are the investor and the issuer in the same shoes? Everyone who has a team allocation of a token is going to lose there. So the first two Howey prongs are mostly irrelevant. Everyone's going to lose. It's the third and fourth Howey prong where the battle is fought. The third Howey prong is the most famous. It asks, is your investment in the quote expectation of profit? The opposite of that would be consumptive utility. If you've heard the term utility token, that is an effort to get around this prong. And really it asks, is someone buying this thing to make money on it, or are they buying it to use it? The same thing can have both consumptive utility and can be bought in the expectation of profit. The example I use is like rare Nike sneakers. You can buy them to wear them because you get social status or they look cool, or you can buy them to flip them. And that would be the difference between consumptive utility and expectation of profit. But of course, there are all sorts of things people buy in the expectation of profit that are not securities. So if you buy a bar of gold, if you buy a rare painting, if you buy a Bitcoin, none of those things are securities offerings, even though they fit. You spent money, you invested money. There is, in some sense, commonality, and you bought them in the expectation of profit. And why not? That is because of the final Howey prong, which is what's at issue here with ETH, which asks, and all of these words matter, is your expectation of profit based on the essential, that word matters, managerial, that word matters, efforts of particular, that word matters, others, which is to say, is there some particular group of people whose managerial, which means business efforts, as opposed to ministerial or just administrative efforts, are essential to you making profit in your investment on the thing? So if you look at Bitcoin, for example, there is no particular group of people who you're reliant on for number go up, right? If the Bitcoin number goes up, it's some combination of market structure, right? Like who is buying Bitcoin? Is it now pension funds finally have access? Is it more people understanding the value prop of Bitcoin? It can be a lot of things, but it's not, we are all reliant on Michael Saylor to push the button for the price to go up. At the other end of the spectrum, if you look at a lot of like smaller crypto tokens, of course, you are betting on a startup to, before the tokens launch, develop the protocol, market it, et cetera, et cetera. And there, I think pretty clearly you're looking at a unregistered securities offering because you are betting on that startup's efforts. The question for Ethereum is that sufficient decentralization question? Is there at this point in time, certainly at the ETH ICO, you're reliant on Vitalik to create Ethereum in order for it to be worth anything. But today, if you're buying Ethereum on Coinbase, are you betting on Vitalik or any particular party to do stuff to make the price of ETH go up? And in 2018, it wasn't a case. It was a lunch talk that one of the SEC directors named Hinman gave, where he said no. He pointed to like a bunch of old cases. My favorite involves whiskey casks, where they did the Howey analysis on whiskey aging in a Scottish warehouse, and said the people who bought these casks were engaged in a securities offering because they weren't buying the whiskey to drink it. They were buying whiskey and then were reliant on the distillery to age it and market it and bottle it so they could make money. That same liquid, when it's sold later in a liquor store in bottles to people who are drinking it, that's no longer a securities offering, even though the sale in the casks to investors was a securities offering. And the argument for ETH that Hinman laid out was the same thing. Yes, in the beginning, ETH was sold as a securities offering, but now when people are betting on ETH, they're betting on the overall ecosystem. They're not betting on the efforts of particular others. And so the question is, does the change from proof of work to proof of stake change that? My view is no. Proof of stake in some ways makes ETH look more like a security because you can get quote unquote yield from ETH. I think that's actually not the way to understand it. You don't get yield just by holding ETH. You have to honestly validate blocks. It's analogous to mining in Bitcoin, but instead of using, energy and, ASICs, you're putting up your own money. And if you dishonestly validate, it's not that you've wasted energy and wasted the use of your ASICs, you lose your money in what's called slashing. So I think what's really going on is stakers are providing a service to the network and getting paid for that service. They're not getting paid for being owners of ETH the way you would be paid dividends for holding a security. I don't think it changes it in that way, but it certainly doesn't change the question of, is there some group that's in control of ETH? Like, I think you can push back on Hinman's analysis and say, oh, the Ethereum Foundation is still super essential to ETH's success in a way that Hinman, disagreed with. And I think reasonable parties can disagree about that. I don't think anything about the merge changes that. There's a separate interesting question about whether staking services for ETH are independently a securities offering other than ETH itself. And there, like, I think it really depends on the setup. Like I said, I think staking ETH on the Ethereum blockchain is not a securities offering. It's providing a service, getting paid for it. I think at the other end of the spectrum, like what Kraken did, where they said they were staking and they took your ETH and then they staked it and decided how much to pay you and decided to validate honestly, as opposed to not. Custodial staking might be a different story, and that might be a securities offering. But I think none of this is to say that ETH itself is security. I think even the SEC knows that. I think the SEC knows that they will probably lose in court with this lawsuit that Consensus is bringing. What I really think this is about is the SEC seeing what happened in the aftermath of the Bitcoin ETF and wanting, a good legal reason to block the ETH ETF, right? They want to slow crypto adoption. I think this is like, unlike what we were talking about before with the DOJ, where I think they're mostly concerned about money laundering, I think the SEC is openly hostile to Bitcoin and crypto, and this is just mostly a pretext.
Yeah, I mean, I think the move to proof of stake really put a target on their back. I mean, that's what it seems like in the Consensus lawsuit as well, with the SEC pivoting and basically investigating the ETH 2.0. It's going to be very interesting to see what they say from the subpoenas about how the merge actually went down behind the scenes. They're talking to the Ethereum Foundation, Consensus. I'd be very curious to know how much, I guess, managerial activity occurred there in terms of directing that.
Yeah, that's the question about ETH, right? Is there a particular group, whether that's, a group of devs who are associated with enough with each other to be like an entity, or the Ethereum Foundation or Vitalik, where like if you're buying ETH, your expectation is they're going to do work for you to make the ETH price go up, and you wouldn't buy ETH otherwise. I think what the SEC is doing is they're looking for any excuse to walk back what Hinman said, which is now politically, they're upset.
Well, it seems like the crypto industry like heard what they wanted, and from that one guy, and we're like, there it is.
Well, if you read the Hinman speech, it's pretty clear.
Yeah,
like, it's a director of the SEC giving a talk about why he thinks ETH is not security. Why on earth would he do that if that wasn't the SEC's position, right? I was in a big law firm at the time, and more or less everyone understood that to mean what it said, which is we don't think ETH is security anymore.
Yeah, no, I got you. I was curious. I've always wondered this, but Joe Lubin, the co-founder of Ethereum and CEO of Consensus, he wrote an opinion piece in the Financial Times, and he said, "Make no mistake, if the SEC succeeds in defining Ether as a security, the ensuing registration requirements would render it unusable.
Yeah,
it would basically ruin Ethereum in the United States." That's what he said. That's what the Consensus, And I always wondered, people argue whether ETH is security or not. Like, I kind of lean towards that path, but I always wondered, like, if it came down, what would actually happen? Like, what would be the outcome? Yeah. And so I would love to ask that, like, what actually will happen, and what are the consequences if they label Ethereum as security, both for anybody who might be holding Ethereum, but also maybe these exchanges that work with Ethereum. Like, what would be the outcomes exactly? Like, if you could just walk us through that.
Yeah, if it was a security, it would have to comply with the securities laws. The most important one would be it has to trade on national securities exchanges, which is not the Ethereum blockchain, right? Like, if you want to know what it looks like to be a crypto token and a security, you can look at companies like Securitize that have these like little walled gardens for security tokens to trade mostly among accredited investors. The whole peer-to-peer thing doesn't work if you're a security.
Just like straight up.
Just straight up. Awesome. Which is why, like, right now, a big argument I have a lot of people in crypto is there's this huge narrative that's getting funded by VCs right now around what they're calling RWA, real world asset tokenization. This idea has been around for a decade. It's
BlackRock
the blockchain
fund, and yeah,
that's only going to be real if the laws change, and probably will only be real in walled gardens controlled by companies like BlackRock. The startups that are saying we're putting real estate, we're putting stocks, we're putting whatever on the blockchain, I think that's basically all vaporware. It doesn't work. Like, we don't have the securities infrastructure to allow that to happen. The SEC, they say, oh, just come in and register. I mean, that's BS, right? Like, there is no way to come in and register and have the thing work. And so, yeah, no, it's totally true. That would basically be it for ETH in the US. I do think they're going to win in court, but it is 100% an existential question.
So is that, like, last question, but like, is that the case that you're just wondering, like, would you say, is it the Coinbase case that you're most interested in focusing on, the Samourai, Tornado Cash? all of them, like
Yeah,
for different
all of
reasons?
them for different reasons, right? As a Bitcoiner, as someone who really believes in financial sovereignty and privacy, the one I feel most personally connected to are the Samurai and Tornado Cash cases that are really about the ability for people to use Bitcoin and crypto in a sovereign way. To me, that's like what we're here for. Those are the stakes. Those are really important.
Yeah.
Economically, it's the Coinbase and Binance and Kraken cases that are going to be, hugely important, because if those come out the wrong way, and I actually think the SEC is going to win all of those cases. I think there's a reason they didn't list ETH. They listed a bunch of other tokens, many of which look a lot like startups, where you are betting on a company.
Yep.
It's hard for me to imagine what sort of the world looks like. I don't know if like lawmakers will step in to write new laws to protect crypto, but like, yeah, that is a real problem for the non-Bitcoin crypto industry that they are not paying enough attention to. And they're incredibly consequential cases. And the deck is like, the SEC just has to show at least one of these tokens. And they talk about like 11 or 15 of them. And it's, all the way from, DeFi, games, whatever, to like bottom of the barrel shitcoins. Like the deck is stacked very much in the SEC's favor in those cases. So I'm very eager to see what happens, when they conclude.
Yeah, I mean, it's why I feel comfy just holding Bitcoin, honestly. Like the regulatory clarity of Bitcoin is something that maybe people don't talk about enough. But in terms of if I'm like an institutional investor or somebody like, and I don't want to deal with any of these increased regulatory risks, this is why Bitcoin maybe separates itself a little bit from the rest of crypto. Not trying to like kick somebody when they're down. It's just like, that's just an objective fact. I feel like,
Bitcoin's the only liquid token I hold too. And I mean, for that reason, and because I know what the supply issuance is, like, that's what makes it good money. That's what makes these other things not good money, because there is a company or group of people who can decide we're going to have more X tokens. And I'm not worried about that happening in Bitcoin.
Hands down. Well, Zach, thank you so much for taking a lot of time to kind of explain some of these regulatory developments to us and sharing your expertise. Where can people find some of your work and follow you, your day-to-day activities?
Yeah, my pleasure. You can reach out on Twitter, Zack B. Shapiro, should be on the video here. My Telegram handle is CoinLawyer, if you want to reach out. And then my website is rains, RAINS.law. If you want to reach out about you're a startup or an investor and you want legal help, happy to help navigate all of these issues and more that we talked about today. In terms of my day job, I do a lot of this regulatory stuff, and then it's a lot of just helping startups with business law and venture fundraising, especially in the Bitcoin and crypto space. And I would just leave sort of one last idea. I want to repeat something I said before, which is like, if you look at the title of the Bitcoin white paper, it's a peer-to-peer electronic cash system. And the thing that's at threat right now in these cases that are incredibly important is the peer-to-peer aspect, right? In order to make Bitcoin reach its full potential, other than just as, a monetary asset, as a monetary commodity, we are going to need good peer-to-peer tools. And while the government's theory in these cases is ridiculous, and I think we do stand a good shot of winning here, the downside is if we lose, that's really going to undermine the ability to create and use peer-to-peer tools in the United States. So please take this seriously. There are going to be announcements soon about ways people can, donate both their time and money directly to this issue. And I hope people, if you care about Bitcoin, if you care about financial sovereignty and privacy, please get involved in any way you can and help us fight this fight.
Thanks, Zach. Yeah, and if you're building, just look at Satoshi as inspiration, I would say. Thanks for joining, man. I really appreciate it. Thanks for coming on Swan Signal Live. Everyone, check out Rains. If you're looking for a good lawyer in this field, check him out. I think he's shown today that he knows his stuff. So thanks, Zach, so much for coming on. Appreciate it.
Anytime.
Well, I think one thing that I'll say is that I just recommend that every listener go read the original source material, go read the actual lawsuits. I mean, there's so much information in there. And if you think that these regulators don't understand this technology, I think you're wrong. I think they're very smart over there, what they're doing, especially when they dig into some of these individual tokens, like in terms of the Coinbase or Kraken lawsuits. They really delve into each one of the tokens they list of why they're security, go through the history, go through the tokenomics. You learn a lot when you read the original source material and do the work and come up with your own opinions on these things. I always recommend that to people. Lastly, check out Swan. We got the 10,000, first 10,000 are no fees. So cheapest way to stack sats today is at Swan. Go check it out. Also, Pacific Bitcoin. That's the festival we put on every year in Santa Monica in October. I'm going to be there. A lot of awesome Bitcoiners are going to be speaking there, as well as a lot of folks over at Swan. Can meet us in person. I would love to meet you guys. If you guys listen to the show, come up and say hello if you guys go to that conference. And you can get 10% off your ticket if you use the promo code Signal, as well as 21% off if you use Bitcoin. So check it out at pacificbitcoin.com. Got another excellent episode lined up for you guys next week. I think we got Mr. Guy Swan. He's a returning guest, Bitcoin OG. I love talking to guys. So I think we got him on next week. And so if you like this conversation, let me know what you thought. Comment, subscribe to the YouTube channel, like it. That always helps kind of get the message out. And I really appreciate you guys listening and supporting this show every week. So that's it for today, and I will see you next week.